Welcome to the CMMC Proof Podcast. I'm your host, Derek Phillips, a certified CMMC assessor and provisional instructor. I am excited because today I have Jim Dempsey joining us today. He's a lecturer at UC Berkeley Law School and a senior policy advisor at Stanford Cyber Policy Center. Jim got his undergrad from Yale and graduated from Harvard Law School. So very impressive resume. It's a really honor to have you, Jim. How are you?
Derek, I'm doing great. You twisted my arm to get me to be on the show, but I'm glad you did. Delighted to be here.
Well. So yeah, you have to go after what you want. I've been following you for quite a long time. I'm like, okay, it's worth a shot. You can't do nothing but say no.
Yeah, exactly.
And it worked out because you're just publishing your book, so at the very least you'll want to talk about your book.
Yeah, absolutely. I mean, and it's so much going on in the cybersecurity field right now.
Absolutely. So I know we have limited time, so we're really going to jump right in. Let's talk about your book, Cybersecurity Law Fundamentals. It's the second edition, and I know you co-authored it with
John Carlin, who's an attorney now, a partner at Paul Weiss law firm, and has just huge experience in the government. He was at the Department of Justice on multiple tours, started as a career federal prosecutor, culminated his career there as acting deputy attorney general. He was head of the National Security Division. He was chief of staff to the FBI director.
Wow.
And he was really the architect in many ways of the current DOJ strategy on cybersecurity. So adding him to the book was a real coup. He brings just such a breadth of experience, as well as now the sort of hands-on experience, on the ground, representing companies in real time, dealing with breaches and ransomware. So It was a delight to add him.
The combination of you and him makes a dream team.
Thanks.
So, that's great. I did order your book. I haven't received it yet. I was hoping to get it before our meeting, but I'm looking forward to reading it and certainly plan on keeping it as a reference guide as I navigate.
I can't promise. I can't promise that you're going to get cover to cover in one sitting. There's a lot in there, but I tried to set it up, Derek, not only for the lawyer, but for the non-lawyer, and not only for the expert, but for the newcomer. And when I was thinking about the book initially, I tried to think about sort of the arc of a cybersecurity incident. So if your company is breached, your first instinct is we've been victimized.
Right.
This is a crime. And so we talk about the criminal law.
Mm-hmm.
But then as this sort of arc of the breach progresses, you often discover that the data compromised was personal information, which then gets you into breach notice. And if you're required to give breach notice, and now those breach notice and incident reporting requirements have quadrupled.
Right.
The SEC is in the act. DHS, through the Cybersecurity and Infrastructure Security Agency, has promulgated an initial a proposal for implementing the CIRCIA, which is the Critical Infrastructure Incident Reporting Act. Just so many different requirements just on breach notice and disclosure alone.
Yeah.
And then, of course, once you disclose the breach, then the lawsuits come.
Right.
And talk about the whole civil litigation system. And then after that come the regulators, both state and federal. And then as your understanding of the incident progresses, and as you bring in your forensics team, not unoften, you find that it was a nation-state attacker. And so then you get into all of the questions around national security law and the powers of the president in the context of national security and foreign affairs. And that's sort of where the book ends up. So it starts with, I've been victimized, to, now I'm on the hot seat and people are blaming me, to, this was a dedicated APT, advanced persistent threat. This was China. This was Sandworm from Russia. This was guys who come to work every morning at 8 a.m, log in and start figuring out how to attack and get through defenses. And they do that day in and day out until they succeed.
Right.
So that's the concept of the book. I'm an academic. I'm not on the ground now. My co-author is, as I said, but I tried to keep it pragmatic. I tried to keep it like, okay, what do you need to know? What if this is your first rodeo? What do you need to be aware of? Whether you're lawyer, non-lawyer, whether you're a CISO, whether you're general counsel of a company, whether you're chief executive of a company, what do you need to be aware of in terms of legal exposure right from the very get-go?
Got it. So what are some high-level tips that you would recommend for companies?
I do start each chapter with some pragmatic tips. Just a page of bullets, takeaways from each chapter. And, number one is you have to be prepared. The bad guys are out there, whether you've got personal identifiable information, financial information, trade secrets, whether you're the owner or operator of a critical infrastructure, very broadly defined, of course, healthcare, power, electrical grid, water. We just saw reports today about another, this time Russian hack of a water supply system. So you need to be prepared.
Okay.
You need to start, of course, with the inventory of your assets, figure out just exactly what technology is running on your systems. And by the way, it's both information technology and operational technology.
Okay. Yeah.
5 years ago, Derek, 10 years ago, certainly, cybersecurity was all about the protection of personally identifiable information, credit card data, social security numbers, health data, etc. And in a way, cybersecurity started as an offshoot of privacy law.
Okay.
In fact, if you go to the root of CMMC, it originates with the protection of that information that the government gives to the contractor, which the contractor is responsible for protecting. But now we're looking at operational technology, all of the industrial control systems, all of the PLCs, all of the SCADA systems that are not necessarily collecting personally identifiable information, but that are controlling literally the valves and the switches of all of the technology that we are dependent upon. And the bad guys are going after those industrial control systems as well. And one of the evolutions of cybersecurity has been, we're not only protecting the information, we are protecting the availability and reliability of the physical infrastructure, which is now totally dependent upon digital controllers, which are increasingly network.
Yeah.
Well, here, just one example. Just in the past month, the Coast Guard issued an emergency directive to operators of port facilities in the United States. Why? Those big cranes that you see, those ship-to-shore cranes that you see, they look like dinosaurs or something, these taking the containers on and off the ships.
Right, they're huge.
Huge and absolutely central to the functioning of our economy, right? Both import and export, it comes by ship if you're talking global trade, and it's got to get on and off the ship using those cranes. Well, guess what? 80% of those cranes at United States ports are made in China.
Yikes.
80% of those cranes are made in China. They are all networked. They are all remotely accessible. And that means they're all vulnerable.
Right.
And an adversary, China or others perhaps, exploiting that connectivity could shut down the economy. If an update were pushed to those cranes and the update was actually a kill switch or kill instruction, trade would be crippled. So that's the recognition which came out of Colonial Pipeline. Colonial Pipeline was the eye-opener there, that this isn't only about the protection of information, it's about the protection of, like I say, the valves and the switches and the cranes and the physical devices which have a networked functionality.
We've certainly seen the battlefield shift from actual front lines to digital space.
Exactly. And so what our book is, what is the law here? How are we using the law to address this problem, both to detect and punish and deter the bad guys, as well as to incentivize the good guys to engage in more effective cybersecurity practices? And there is no single comprehensive cybersecurity law in the United States.
Right.
Instead, we have this patchwork, almost a crazy quilt. Some quilts are all very logical, and there's one actually called
Right.
Log Cabin. Every little piece of fabric is the same size, and it all fits together. And then there are
Right.
the crazy quilts where the farm ladies or the folk craftspeople took
Mhm.
all different size shapes of
Different
fabric
colors, everything.
and all different and wove them all together. And that's what we have. We have common law, negligence, concepts that go back hundreds of years, right? Negligence and contract law. And then we have criminal law.
Yeah.
And then we have regulatory law. And we have state law. And we have federal law. And we have standards. And we have sectoral law. And we have the national security powers and the trade regulation powers. And this is what I try to do in the book. We try to make sense of this.
Yeah.
And, we're stitching together this quilt. And even as we're doing that, other pieces of it are falling apart, or we're realizing they weren't adequate. And so that's what the book is about.
Okay.
How does this all work together? What is the role of the law in enhancing cybersecurity?
That's awesome. And I love the fact that you said start off each chapter with at least practical guidance that can help those readers take action.
That's right.
To your point with an asset inventory. So many companies don't even have an asset inventory. So that's just like the basics.
Exactly. And it's the basics for privacy. It's the basics for cybersecurity. What do you have? What's connected to your network? What systems are you operating? What data are you holding? Because whatever personal data you hold, you are responsible for.
Right.
And if you're a critical infrastructure, increasingly the government is looking to hold you responsible there. So you start with the asset inventory. You identify risk. You develop your mitigating controls and measures, and then you go back. Then you monitor, of course, your networks, and then you go back periodically and reassess based upon changes in the threat, changes in the technology, lessons learned from attacks. You look at some frameworks, whether the NIST cybersecurity framework, they are very, very useful, and they are very, very usable, I say. But the Center for Internet Security has its critical cybersecurity controls list. Used to be 20, now it's 18. Used to be 20, now it's 18. That just boils down. Now each of the 18 has subparts. But even if you just look at the top 5, and I think number 1 is inventory. Your clients, Derek, and many of your listeners, they're bound by contract,
right,
to implement 800-171 because they hold CUI, or they may be bound by 853 because they are providing a communication system to the government. And okay, you've got to go through all 110 controls, and now we'll see where CMMC takes that and the tiering.
right.
You got to do what the contract says. But I like that CIS top 18 because it's much simpler. And it at least starts with the basics, and it has a sense of prioritization. I feel the pain of your clients when, they look at that list of all of the controls.
It's overwhelming.
It's overwhelming, it is. But on the other hand, it's hard to look at something on that list and say, well, it shouldn't be on the list.
Right. Yeah,
right.
That's the challenge.
Right.
So with the research you've done with this book, and then with your co-author, his experience on the front lines, what are your thoughts as far as how the U.S. is approaching cybersecurity and privacy with the various laws? Do you think that it's effective? Do you think it's improving the posture of companies?
So again, I think we are constantly seeking to improve. Now, we've got one problem in our country right now, which is Congress is pretty gridlocked, and it's hard to get things out of Congress.
Yeah.
People keep talking about, will we have a comprehensive privacy law? In fact, just today, as we're recording this, I think there was a hearing on Capitol Hill. A new bill was introduced. Very, very, very hard to get anything through Congress. CERCIA did pass. That was a big step. The reporting critical infrastructure incident and ransomware reporting, which hasn't yet kicked in. The rules are being drafted. That won't kick in until next year. That was sort of a big deal. A couple of years ago, Congress passed a tiny little provision on the Food and Drug Administration, making it clear that the Food and Drug Administration has authority to issue cybersecurity standards for connected medical devices.
Okay. That's a start.
It's a start. And
Yeah.
it's and the administration in its cybersecurity strategy of March 2023, just a year, 12 months, 13 months ago, said that it will use existing authority where it can. So I mentioned that directive on cranes at ports. There is an existing law on port security of port facilities. It goes back decades, if not longer. And the administration said, well, security of ports, that used to mean protecting against physical sabotage. Now it includes digital sabotage. So we're going to use that existing authority. That's what the Transportation Security Administration did with pipelines. It did it with aviation. So the administration has been taking this sector by sector approach. And at some level, that I think is maybe the best we can do. Okay? Because what works in one sector, what is required in one sector, is not necessarily going to be the same in another sector. And we are probably always going to have sector by sector enforcement. So the Coast Guard is responsible for ports. TSA is responsible for aviation and other transportation. Federal Energy Regulatory Commission is responsible for the bulk electrical power system. NERC, the National Nuclear Energy Regulatory Commission, is responsible for nuclear. FCC is responsible for communications, etc. So my motto on all things policy is think comprehensively, act incrementally.
Okay.
Which is you've got to have some vision. You've got to have some overarching concept. But in reality, in order to act, you're going to have to act step by step, sector by sector. Now, I would love to see Congress do for water system what they did for connected medical devices and make it clear that the EPA or some other agency, I think the EPA is the logical choice. They already regulate drinking water in this country in collaboration with the states. I wish Congress would act and do something on drinking water to make it clear that the EPA has the authority to address the cybersecurity of the control systems for the drinking water system of our country.
Pretty important.
Pretty important.
Critical.
I wish that Congress would do something that would expand the authority of FERC from the bulk electric power system down closer to the last mile of distribution, which is currently not regulated. When you think about switches in the telecommunications backbone, we've had an effort over the past, 10 years now to get rid of all the Chinese manufactured switches in the telecommunications network. A Chinese company named Huawei and another one called ZTE had made these huge switches that serve as part of these digital switches that serve as part of the backbone of the telecommunications infrastructure. They had gotten a little too deeply embedded into the U.S. infrastructure, and now the FCC has a program to rip and replace those Chinese-made products with products that aren't made by companies under the control of the Chinese government.
Right.
But meanwhile, we have nothing for the homemade stuff. Now, the homegrown stuff may be vulnerable too, and I wish the FCC would take that on. So I think there's clearly, there is no doubt, a lot more that needs to be done. Okay?
Yeah.
A lot more needs to be done. The bad guys are racing ahead, of course. They are always seeking to innovate. We've seen some very, very sophisticated attacks, the intrusion on Microsoft Exchange, the SolarWinds, supply chain attack, extremely sophisticated. So are we doing enough? Obviously not. Anybody who's honest would say we're not where we should be. Anybody who's honest would say we are vulnerable and we need to do more. And unfortunately, we're in a political climate, a legal climate, Washington, D.C. climate, where it's very, very hard to get things done.
Right, I agree. Does your book address the various privacy laws at the state level? Because we see states enacting their own privacy laws.
We often say the states are the laboratories of democracy. States also, of course, will fill a vacuum left by Congress. So we now have, as of April 4, with Kentucky, the 16th state adopting a comprehensive privacy law for data privacy. Those laws are so-so from my perspective in terms of privacy, but every one of them also contains a cybersecurity provision.
Okay.
Saying that companies doing business in those states must protect personal data they collect with reasonable security measures, and we'll get to reasonable in a second. Even before this current wave of comprehensive state privacy laws, a number of states had freestanding reasonable security measures. So there are now about probably close to 30, I've almost lost count, it may be a little one or two over 30 states who have one, and in some states two, laws on the books saying that a business doing business in that state and collecting personal information of residents of that state must protect that data with reasonable security, administrative, technical, and physical controls. Those laws, by and large, do not create a private right of action. An individual citizen cannot sue to enforce them, with the exception of California, and even there, the private right of action is limited.
Okay.
By and large, these laws are enforced by the state attorneys general. A very mixed record. I think New York State has been pretty active, California active, a few other states come and go. I would really love to see one or more state attorneys general take up this issue on behalf of the citizens of their state and start enforcing these laws. But again, these laws only protect or only aimed at the protection of personal information.
Okay.
They're not aimed at the whole operational technology side of things. So they don't address the water systems, which are generally very highly decentralized. They don't address the power network. They don't address other infrastructures, transportation, railroads, et cetera, at the local level. But the states are looking to fill that vacuum. What is the enforcement commitment behind that remains to be seen.
Okay. To be determined.
Yeah.
All right. And my last question for you before I let you go is regarding the DOJ's civil cyber fraud initiative.
Yep.
What are your thoughts behind that, and whistleblowers and some of the high profile cases that we've seen with Georgia Tech and Penn State, for example?
Yeah. So this is starting to get some traction, I think. And I actually learned from one of your guests that a large percentage of these false claims. So this goes. You've talked about this with a number of your other excellent guests who are deeper into this than I am. But the False Claims Act says that it is a civil and sometimes criminal offense to enter into a contract with the government, promise to do something in that contract, and then fail to do it. And when you submit your invoice for payment, that's the claim. And you're saying, okay, according to the payment schedule in my contract, here's my invoice, but you haven't done what you said you would do. And in our case here, what we're worried about, what you and I are focused on, you haven't delivered the cybersecurity controls and protections that you were bound to provide in the contract.
Right.
And we all know that there are a lot of people out there getting paid under government contracts that have, whether it's the FAR provision or DFAR provision or other contract provisions that bound them to meet a certain cybersecurity standard. We know that there are a lot of people who are not compliant with that standard. And when they submit their invoice, that is potentially a false claim against the government.
Yeah.
And the statute is very unique in that it has something called, this is legal Latin, qui tam, or qui tam, Q-U-I, he who, he or she who in Latin, tam, I don't even know what that means in Latin, on behalf of. But basically, it allows an individual, a whistleblower, someone in the company who said, hey, guys, we're doing this contract and we're submitting these bills, and you and I know we are not up to snuff on cybersecurity. And you and I know we've got stuff undone on our cybersecurity and we're not fixing it, and yet we're still getting paid under this contract. Finally, that person gets fed up, and sometimes they quit or sometimes they try to stay in place, but they file, the whistleblower files what is called a qui tam action. And the caption of the case is Jane Smith, ex-rel on behalf of the United States of America versus government contractor.
Right.
And basically the whistleblower is saying, okay, I'm in here, I'm on behalf of the U.S. government. I'm not getting ripped off, I'm getting paid. still, even though I hate my job. I'm not satisfied with the way we're doing
frustrated.
this work.
Yeah.
I'm frustrated, but I'm getting paid. But the person who's getting hurt is the U.S. government and the taxpayer. Well, I'm going to come in on their behalf. And that's these so-called key TAM actions, these whistleblower cases. And under the statute, if the case is successful, the whistleblower gets a share of any penalty, of any fine, of any remedy. The main relief goes to the government, but the whistleblower shares in it. So that's a huge incentive. Not only are you able to do what you think is right, but you can get a reward, basically, for coming forward on behalf of the government. And what the Justice Department said 2 years ago was, we're going to encourage more of this. We're going to look for cases ourselves. We, the government, are going to look for cases. And if cases come to our attention, we're going to bring them. If there was a breach, or in the case of Verizon, recently Verizon settled a case. Verizon actually self-reported the defects in its product. It was offering I think a cloud communication service, a cloud storage service to the government. It didn't meet the necessary standards. Finally, someone at the company itself came forward, and they ended up paying a significant fine, less than they would have paid if they hadn't come forward themselves.
Exactly.
So kudos to Verizon, at least for finally coming forward. So we're going to see more of these. The Justice Department will be on the hunt for these, but also I think, I don't know for sure, that the Justice Department will be supportive of the whistleblowers. There was a tendency in the past often for the Justice Department to sort of disrespect the whistleblowers, because the government can actually come in on a case and take the case over, take it away from the whistleblower, and end up dismissing the case if the government thinks the pain you're imposing upon the contractor and the disruption is actually greater than any benefit we're going to get out of this. The government can't dismiss the case. Again, TBD, but it's on the radar screen. Penn State, Georgia Tech, I think both
Verizon,
of those whistleblower cases. Verizon self-reported.
Boeing, but I don't know if that wasn't cybersecurity.
Aerojet Rocketdyne
that was settled.
Was one that settled, and the whistleblower got $1 million. So I think we're going to be seeing more of that, and it is a motivator, I think. I think it is starting to get people's attention. And I think, last point, Derek, what would be nice is if there's sort of an intersection between the effects of False Claims Act and the final implementation of CMMC, at least on the defense side. Because in my view, your listeners are, again, deeper into this than I am. You're deeper into this than I am in the nitty gritty. But looking at it from the outside, I think CMMC is a recognition of what we've been doing hasn't been working.
Right. A self-attestation.
Self-attestation where everybody says, oh, yes, I do all 110.
We're good to go.
That's just wrong. It's wrong to accept those self-attestations. So what we've got to do is we've got to make it more reasonable. Get a narrower number of controls for the lowest tier, and then ratchet up the accountability, including the third-party assessment. We could do a whole thing on third-party assessment and what that means.
Next time.
But I would like to, in other words, if the expectations become reasonable, such that no people stop playing the game of saying I'm meeting all these when in fact the contract officer winks and nods and knows you're not meeting all of them. If we could get a reasonable set of requirements and actually stick with them, then the False Claims Act comes after the people who are misrepresenting that which is achievable. I think right now a lot of people are misrepresenting on the grounds, hey, everybody does it. We're not going to get the contract if we don't misrepresent. So let's just say we're compliant even if we're not. Because, hey, it's impossible to comply anyhow because it's so complicated and there's so many of them. I think I see CMMC at core as an effort to introduce reality to that whole contracting process and to take the gamesmanship out of that. And then, then False Claims Act is totally justified because now if we've right-sized the controls, depending upon the sensitivity of the contract, and if we're truly holding people to those controls, then in comes the False Claims Act, and that's the hammer.
Makes a lot of sense. That's a good one to close out on, Jim. I really appreciate your time being so generous.
Really loved it.
It did. But where can people find your book?
So
Before I let you go.
It's published by the International Association of Privacy Professionals, IAPP.org. Go to their website and look under resources, or just search my name or search the name of the book, Cybersecurity Law Fundamentals. It's available in both digital